Supreme Court of India 2023 INSC 965 ANIL KUMAR vs. the State of Kerala decided on November 1, 2023 facts, accused with the intention to kill his wife. Lighted a matchstick and threw it upon her when she had already poured kerosene upon herself due to the quarrel. FIR was initially registered under Section 307 IPC when the deceased wife died in the hospital. The case was converted into that under Sections 302 and 498A of IPC, both session and high, sentenced to life imprisonment and fine. Findings of the court. First dying declaration Exhibit P1 made before the Judicial First-Class Magistrate. Other statement which can be read as a dying declaration is Exhibit P10 recorded by Head Constable clearly reveals the cause and circumstances of the death of the deceased wife. Both the above statements, if read together, would reveal that on the fateful day, the appellant had assaulted the deceased wife under the influence of alcohol. He even struck a blow on her chest and pushed her. She took the cane of kerosene from kitchen and poured it on her body, whereupon her husband lighted a matchstick and burnt her. The magistrate, PW5, before whom one of the dying declarations was recorded, proves the correctness of the statement and that when the statement of the deceased was recorded, she was coherent and oriented. The statement of PW5 was supported by that of PW14, Dr. K. Venugopal. The DW1, Saji Matthew, also proved that the deceased, at the time of the admission in the hospital, narrated about her burn injuries and alleged that her husband assaulted her and that she had poured kerosene on herself, whereupon her husband had set her on fire. The medical report reveals that the deceased had suffered 96% burn injuries. The incident was also proved by the oral testimony of PW1, Sahajan, and PW2, Gopalakrishnan, the neighbors who took the deceased to the hospital in a jeep and have seen the deceased in burning state. The overwhelming evidence on record, there is no escape from the conclusion that the deceased died of burn injuries. She had herself poured kerosene upon her body and that the appellant set her ablaze and later tried to douse the fire by pouring water. The appellant, upon seeing the deceased drenched in kerosene, clearly took advantage of the situation and lighted a matchstick and threw it upon her so that she can be burned. The appellant, having taken undue advantage of the situation, cannot be extended the benefit of exception 4 to Section 300 IPC so as to bring the case within the ambit of Part 2 of 304 IPC. Courts below have not committed any error of fact or law in convicting and sentencing him to a maximum punishment of life imprisonment. The appeal accordingly lacks merit and is dismissed.